I had no knowledge or involvement in this issue, in its planning or its execution, and I am stunned by the abject stupidity that was shown here.
Didn't know, and it wasn't just when it was being planned, didn't know even until he learned about media reports, the governor told us, and he made it clear those involved, including David Wildstein, who we'll talk about in a second, abject stupidity and worse. Now, he stated as clearly as he could that he has no fingerprints on this thing whatsoever. Forget about the lane closures, the political payback. There were no fingerprints of his on any of this. And in fact, most importantly, it's not just that he didn't know and was involved in the planning. He didn't learn until all of us did through media reports. Okay. Document dump back in January showed it was an act of political payback, as we now know. And again, the questions, as it always does with every investigation, who knew what and when they knew it still exists. And going right to the governor here, did he lie to the public on January 9th when he said, "Don't look at me"? Well, the man who released those documents now says you should look at the governor. And for more, I want to bring in our senior political correspondent, Andrew Whitman. Andrew?
Well, Rich, the man who Christie says lied to the public at that press conference is David Wildstein, the man Christie appointed as a senior official to the Port Authority, the man on the receiving end of that "time for some traffic problems in Fort Lee" text, and the man Christie absolutely threw under the bus at that press conference. Wildstein now wants the Port Authority to pay his legal bills, so Friday, his lawyer released this letter looking for the authority to do so, and looking for an immunity deal in the process. In the letter, Wildstein's lawyer says he contests the accuracy of various statements that the governor made about him, and here's the key point, he can prove the inaccuracy of some. In other words, he can prove that the governor lied. Team Christie responded Saturday with a long email they sent to Politico, that email essentially trashing Wildstein, calling him tumultuous and someone who made moves who were not productive. The memo mentions a school board lawsuit filed when Wildstein was 16. And it says Wildstein was, quote, publicly accused by his social studies teacher of deceptive behavior. Here's the bottom line to the email. It says, well, they also attacked the New York Times with some of their reporting on the story. But bottom line, it says, David Wildstein will do and say anything to save David Wildstein. Which begs the question, why is Christie smacking so hard back at Wildstein? Well, this poll gives you an idea. If Christie knew about the bridge closure, 2/3 of New Jersey residents say he should be impeached or prosecuted or both. Two additional bits of Christie news today. Another resignation. Christina Renna, who reported to fired Deputy Chief of Staff Bridget Kelly, left the administration Friday. It was announced during the Super Bowl yesterday. Renna says the decision was not connected to Bridgegate, but she was among those subpoenaed in the case. And one other note, today is the first day subpoena requests are due back in the legislative committees investigating Bridgegate. Subpoenas to the U.S. attorney are due tomorrow. There have been reports that some of those subpoenaed have complained or sought more time to respond to the subpoenas for documents in this case. Fox 1 reporter Kimberly Wallace sat down today with Assemblyman John Wisniewski, who's heading the Joint Investigative Committee. Her first question was about the timing of those subpoenas and the responses.
Well, no subpoenas have been deferred. A number of attorneys have been in touch with our counsel discussing the logistics of delivering what potentially could be a lot of documents. What we've instructed our counsel is to agree to reasonable accommodations to facilitate the production of documents. We do not want to be unreasonable to anybody who's working to comply with our subpoena. We also just don't want to agree to anything that would frustrate the purpose or the intent of the committee subpoenas.
Kim then asked the chairman what kind of information they're receiving in these subpoenas.
I don't know what we're getting. I mean, honestly, we've asked for material. I know that as we speak, some material is beginning to be received, but I've not had any opportunity to review it, nor has staff, because of the weather. And so we'll get to that as soon as we can. But what we have to do is analyze it carefully to understand whether the fundamental questions that the committee has have been answered. And that really goes to why was one person in the governor's office directing operations at the Port Authority in a way that abused her power, and why did that person at the Port Authority accept that directive in a way that abused his power?
Wisniewski noted they do not have a specific timeline for when they might release documents being subpoenaed or when they might put those people under oath in public hearings. Then the big question, does Wisniewski think this information links back to the governor?
Well, I don't know where it'll lead, and I think that's a fair approach to take. When we started looking at the Port Authority, we were looking at their operations and finance. And during that process, somebody decided to close lanes out of Fort Lee, which prompted us to continue to look into that lane closure. What we expected and what we found were two different things. We expected to find an agency that was poorly run, that had people engaging in a variety of activities without any oversight. What we found instead was a trail that led back to the governor's office that showed an abuse of power and an attempt to cover up that abuse of power. So now that we're there, we have an obligation to find out how it could happen and how we could prevent it from happening. I can't predict where it'll go or what other questions we're going to ask, but we do need to get answers to those fundamental questions.
All right, so there you have the back and forth. We're going to learn a lot more, but trust me, we're not talking days here. This is weeks, maybe even months. For more, I want to bring in our panel tonight. Dominic Carter, of course, political journalist, author. You met Andrew, and we're joined by Bill Aaronwolf, former federal prosecutor, now criminal defense attorney. And Bill, I want to start with you. You saw the letter, and there was a key portion of the letter where he says, evidence exists, this is Wildstein's letter, as well, tying Mr. Christie to having knowledge of the lane closures. Evidence exists. And then he goes on to say, contrary to what the governor had to say publicly in that 2-hour press conference. Okay, didn't say he had the evidence, but he says evidence exists. Before we get into the letter, why did the attorney put out the letter unless he already has a plea agreement in his hands? Is there anything that could be in the letter that can compel him to testify that he now has, I guess, material evidence or knows about the existence of?
Well, I mean, a lot of this is public relations stuff. You know, I mean, basically, you got the court of public opinion and you got the real court. Last time I was here, and I say it again, I mean, I don't see, from everything that we've heard about and read about in the media, that there's any viable federal criminal offense that the governor could be charged with, assuming they have any evidence. I mean, I think it's odd that the governor says he wasn't aware of the lane closings until he heard about it. I mean, but I remember when there were the lane closings and everybody was reporting about it and talking about how traffic was being obstructed.
Specifically to Wildstein now.
Yep.
You're his attorney.
Right.
Why do you put out a letter? It seems like he's fighting over his legal bills aren't getting paid, right? You put out a letter where you don't just say there's a compelling reason why you should. You go on to say, hey, the governor in that press conference, he's misrepresenting the truth, and I have evidence to produce, or I've seen evidence exists at least, that Christie had knowledge of the lane closures, which is directly different than what he said. I'm not saying he planned it, but he said he didn't learn about it till the media told him.
Well, he also says in the letter that some of the statements that Governor Christie made are demonstrably false, and he has the evidence to show that. Well, you ask a very good question. I mean, basically, if you've got the goods, you know, then why put it out there publicly unless you've been trying to get some sort of a deal of immunity from the government and they're not biting? So what you do is you release the statement publicly because now the public starts saying, well, if he's got the goods, let's hear what they have to say. And he says, well, my testimony comes at a price. The price is immunity. From a practical point of view, if the attorney knows that his client has evidence to show that the governor lied, whether it's a criminal offense or not, he should be banging at the prosecutor's door saying, this is what I have. Okay, I'll give it to you. All I want is I want my guy to get immunity. So the fact that he's doing this in the form he's doing it suggests to me that he's been knocking at that door, and whatever he has is of no interest to the prosecution or the government. Either
a strong enough case they don't need it, or more likely they're just not sure what he has. Now, I'll give you the second thing. You're Bridget Kelly, or you're the counsel for Bridget Kelly, who was the most notable name in that press conference that was thrown under the bus and fired on public TV. Does she say, time out here? Somebody's trying to get ahead of me in line here. If there's a deal, my client should get it. Kelly's attorney, what's she doing right now?
Well, I think all of these people, their lawyers, are all basically trying to get the government to give them the bite of the apple because, you know, basically it's an old saying the prosecutors have. You know, whenever they're confronted with all of these people who are saying, look, I can do this, I can do that, they say, well, look, you know, the train is about to leave the station. First person on the train gets on board. The rest of the people are left behind. So basically, with everything that's going on, you would think that if there is a crime here that someone's looking at it from a prosecutorial point of view, you got all of these people saying, well, I could do this, I could do that. It's like I said last time. You look for the weakest link, and that's the one you try to turn. That's the one you try to flip. You want to trade up. You don't want to trade down. You're not going to go to the big fish to get the guppy. You're going to look at the guppy to get the big fish. And so that's the agenda. That's the psychology of these things.